So we were talking about wills before in our other three installments, as Onika mentioned, the last part for this series. And we are comparing wills and deeds of gifts because we're talking about the gifting part of
Right.
wills. Yeah?
That's right. I like how you put it, the gifting part of wills.
Yeah. Yes, because and when we wrap up, I want hopefully or the end of when you represent what wills can do, also highlight that for a will it's not just about the gifting part. But for today's segment, I think the best thing to do is talk about the gifting part of wills and compare the pros and cons to use utilizing a will to gift as compared to its counterpart deed of gift under title. So, with no further ado, you take it away the gifting parts of a will. And if you could legally break that down for our listeners.
All right, let's talk about, as you rightly said, the gifting part of a will. The first point we want to establish for our listeners is that everything you put in the will, in a sense, is a gift because it is what you have that you are giving to someone. If it is property, it is described as a devise, devise. If it is pecuniary, jewelry, furniture, etc., it is just a gift. But once it's land property, it's a device. So the point is, you can gift your real property to someone in a will, and it takes effect as every other gift on your passing. That is a critical thing. And when Onika comes, Shakila comes in, we will see the major difference is the time factor, when which one takes effect. And probably we can start there with the differences. One takes effect only after your passing, and it must be probated because you would have done a will. So therefore, then let's have this imaginary property. We all love West Moorings or Valside. So we are going to say number 01. No place has that number. So number 01, West Moorings Place. So you decide to gift this place to your, let's say, your spouse on your passing. We have to go for probate. So the first thing, even before you gift it in the will, astute as we would want to make sure that we see that deed before, because we've spoken about it at length, to make sure that you really own what you want to pass on. So that's the first thing. So once we've seen the deed and we are sure that you are the sole owner of right, we will then say, make a device in the will. We probate. And only when the executor has the grant of probate can we now move to the next stage that is called the deed of assent. So, Shakila, I'm suggesting right there you jump in and talk about the difference in the time element.
Sure, certainly. So we've reached to the first difference there. With a deed of gift, the gift takes effect immediately. As soon as the deed is prepared and executed, at that point there is a change or a transfer in title. Of course, it will also be ideal for the deed or um the certificate to not the certificate, the transfer to be registered. And I want to also speak of those two things. The title change of how you gift your property is also going to be governed under which form of deed of title registration your property ownership falls. So if it's under the RPO, you will be required to create a memorandum of gift, and you will have to prepare and register that document and endorse the CT or the certificate of title to illustrate the said gift. Only then would it be effectual in law. Now, it doesn't have to be endorsed to be effective, but you need to you need to execute your deed of your title of gift, whether that title be a memorandum of gift, or if the title is registered under the old law system, a deed of gift. When you do so, the interest in the property is given to the donor immediately. And that is who we reference, and that's another difference we just came about there. In a deed of gift, the person benefiting is not a beneficiary. They will be termed as a donee, as if you would have donated something to them. You will not be referred to as the testator, as in a will, but the donor, or the person donating this gift. And you get your gift immediately, meaning that you will one time be the owner of the property, the real property. All right. um do understand though, when we're talking about gifts in wills and doing a deed or a memorandum of gift, it speaks really more so to real property, or property that only can be given in this manner. All right. When other things, as Mrs. Joseph would have mentioned, such as jewelry and others, may not necessarily form part of this option for you. Right. And so we're not saying that, well, if you do a deed of gift, there's absolutely no need for a will. And Miss Joseph, maybe I could ask you about that. If the person who has these things do not have real property alone, but may have shareholders' interest in a company, right? They may have interest in, they may have jewelry, pets, different things that we would have seen listed on other things. Do you see necessity still for a will, and why? Or can these things be covered in a deed of gift? That should be the question.
No, well, let me
Yes.
talk from my experience. All
Yes.
I have seen in a deed of gift is real property. I haven't seen anything else.
Okay.
However, I have definitely seen in a will monies being sent to charity. I have also seen people willing monies for their pets to be taken care of when they have passed on. So, in a sense, the will is far more encompassing. You can put a lot more in there in
Yes.
terms of charity, your pets, your shares. However, the deed of gift, based on all that I have seen, you can only gift real property to another person.
Yes. Yes, and if we were to legally reason it out, I know we may perhaps have young attorneys here on this. You need to understand that title falls under property law and wills fall under probate. It's two different types of laws completely. And the reason for that is because deeds and title documents, a deed or a memorandum of gift could only speak of property, real property, as governed by the said act, etc. It's two different types of laws. You cannot include gifts of that kind in a deed of gift, because title documents speak only to title. Yeah. And that's why you cannot have a car in a deed of gift and stuff like that. So because it's title. So we want our participants to think of that and remember, take into consideration, if you would like to include gifts that do not form part of title, you need to make provisions for that. And it reminds me of recently I went to a new restaurant open, beautiful restaurant, shameful plug, Arazi on Maraval Road, Avian. We have to go together. Wonderful place. And there were lots of young professionals linemen there and talking and stuff. And a very known businessman, young businessman, stood up and quite arrogantly declared, well, my mother does not need a will because, I am joint on all her things and the property. And he kept talking about the property. And I said nothing, but I'm thinking to myself, there is so much more autonomy that is given and afforded for with a will, and appointing someone, an administrator, that goes beyond the gifting part of a will.